Hey, live on Facebook. Hey, everybody. I hope you guys had a great day. So, we're here tonight to talk a little bit. Been having a little trouble with this Facebook stream. Apparently, Facebook and Zoom are like giving each other a hard time or something. I don't know. But Zoom would not let me on Facebook. And so now I had to go with StreamYard. So, I'm using a different service. So, it might be a little rough, but I think this new service is really nice. So, we're going to get started here. Got a couple things we want to talk about today. Advocates for Justice, Foreclosure Defense Paralegal Service. We are different and we prove it. I'm Coach Neighbors. Most of you guys know who I am. Tonight, we're going to talk about a couple of things. The main thing we're going to talk about tonight is the jurisdictional challenge with an affidavit. So those of you who are using that, you must make sure you do your homework to decide to figure out how long the attorneys have to answer. The problem that people are running into with that document is the attorneys are dragging their feet on answering, and people are not aware of how many days the attorneys have to answer. And if the attorneys don't answer, you have to do something about it. You can't just let it sit. What's been going on is attorneys haven't answered, and no one files for a default against attorneys for their failure to answer. So the judge figures out that you don't know what you're doing, and he thinks that you're waiting, or she thinks you're waiting for her to rule. So she dismisses your claim, and that's messed up. Your jurisdictional challenge, because if you read the challenge, you'll see that what you're doing is you're ordering the judge to demand the attorneys prove jurisdiction on the record. And the motion to moot all of the pleadings in the case until jurisdiction is proved on the record, that's not something the judge can dismiss. So I've had a couple of people the judge dismissed it. I think what's happening here is when the judge violates you, if you fail to take action and do something about it, then they're just going to keep violating you, because that's how they roll. They know that they have an 85 or 90% chance that you're not going to be able to do anything about it, because you can't hire an attorney that's going to go after the judge. We already know that's not going to happen. So they can get away with this stuff because they don't think that people are going to step up and do anything about it. So as soon as the judge dismisses your, at the end of the day, it doesn't matter if you sue the judge or if you're suing the attorney or the judge and the attorney or the clerk. It doesn't matter as long as you're suing somebody. And where it's blocking you from getting in court is the person that you need to be looking at as putting on your paperwork for the number 2 or number 3 or number 4 defendant. Now, we don't really like to add too many defendants because it gets a little complicated if you add too many people. But at the same time, you want to make sure the people that you got on there are the people that's messing with you right now, not all those other people that are from the past. So when you use this jurisdictional challenge with an affidavit, you must make sure you keep track of the days. You must do your research to find out how many days they have to respond. And you should have your default ready. The day they're in default, that same day, you should be at the courthouse sticking your stuff in the clerk's face and telling the clerk to file a default against them because they're in default. They have not responded. Now, I added a document to that, a motion to dismiss for failure to litigate. So if they haven't filed, haven't responded, and even if you filed your motion for summary judgment, this motion that I put together to dismiss a failure to litigate might be something that we want to consider using, because it allows the judge to dismiss it on the attorney's failure instead of the court's lack of jurisdiction. It's a little sticky thing because the courts don't like to do stuff that's going to show other people how to come in there and kick their butt. So this might be something that we can use to kind of change the program a little bit and go ahead and get your stuff on the record and challenge the court's jurisdiction. And then if the judge denies it or interferes or blocks them from or answers on their behalf, then you're going to need the reconsideration package, the magistrate judge reconsideration package. In that package, you have the documents that you need to demand reconsideration. You have the documents you need to recuse the judge. You have the documents you need to file a claim against the judge if you need to. The notice of claim is the actual claim. It's just written up as a notice of claim to stick it in their face and try to get them to comply without having to go through all of the troubles to add, to have another lawsuit on top of what you already got going. And in most cases, it works pretty well. So you'll need to keep that in mind. So the notice of claim is the notice of claim is a pretty valuable document, and that you're going to be holding against a judge. And it's pretty powerful. It's very powerful. As a matter of fact, the main thing that you're going to be going after them, the judge, for on that notice of claim is for a violation of the Administrative Procedures Act of 1946. Now, if you are going to research this, you're going to have to make sure you put in 1946, because if you put in Administrative Procedures Act, then you don't add of 1946, then you'll come up with Cornell Law Library watered down BS that ain't even nowhere close to what the real document is. Now, the Administrative Procedures Act was actually enacted into law in 1946, if you didn't figure that out yet. And what that law does, it's a federal law, and what that law does is that law mandates that all corporations must have their policies and their procedures in line with the Constitution. We already know that's not the case. So the Administrative Procedures Act of 1946 is an administrative issue, and if you win, you can force the court to change their policies and their procedures to make them be in line with the Constitution. And you know they're not going to want to do that. Now, you also are going after them for constitutional violations and conspiracy, Section 242, and some other things. Those are where the damages come in at. The Administrative Act of 1946, you can't claim money damages on, but you sure can force them to change their policies and procedures. And you know they ain't want to do that, because if they make their policies and procedures legal, they're not going to be making any money. They're not going to be making any money if all of the stuff that they're doing is the right thing. And we already know that. So that's the way that rolls. So if you're using that document, if you're using the jurisdictional challenge with an affidavit, you must make sure that you know how many days they have to respond. And if they don't respond in the number of days that they have to respond in, you need to take action immediately. And you need to get them jammed up. Now, the way this is set up, the jurisdictional challenge with an affidavit is to be filed in state court to blow up that whole state court case. And then when you file your lawsuit in federal court, you can use all of the file stamp documents in state court, because they're not going to be able to answer to it. And if you stop and think about it, a jurisdictional challenge by an affidavit has to be answered with a counter affidavit. And they can't respond by counter affidavit because they're lying and full of crap. And so that creates a real problem for them. So that's one of the things that we're doing to use their own rules against them, right in their face. So, but if you don't keep track of the time, the judge is going to respond and throw your stuff out, and then you're going to be going after the judge. So let me check and see here. I'm using this new program, so I haven't quite got used to it. Okay, share screen. Let's see if I have any comments. Can't post comments in the group. I don't know why that is, but I'll work on that after a while. So the other thing that I've done is we're having a sale for this weekend on both the non-judicial and the judicial lawsuit packages. I'm going to reduce them down to $300 as I said I would and the radio show on Wednesday. So for all of the radio show, HamiltonRadio.net listeners, you're going to get a break this weekend. And also for people in the Facebook page, obviously, and the people that follow me on the YouTube channel, you'll all get a break this weekend. Now, if you buy the package on sale this weekend, then if you have questions, you're going to have to talk to me about those questions in the group. Because when I do the sale, I don't provide the same phone service that I do when you pay full price. And if you stop and think about it, all the people that paid full price, it wouldn't be fair to have a whole bunch of people taking up the line when they got. So you see what I'm saying there. So if you have any questions on the document, you can hit me up in the Facebook page, and I'll leave a link to our Foreclosure Rescue private Facebook group. And then you can get in the group. And then if you have questions about the document, you can ask in the group. Most people, a lot of people in the group are past the point where you would be if you just are signing up. So they should be able to help you. And that's the idea of the group in the first place, is to make the support be from people that have already done this or that are in the process of doing it. Because at some point along the way, I'm going to be pretty busy, and I won't be able to get your calls and your emails and get them answered in a timely manner that's going to help you if you're putting your paperwork together. So, and the Facebook page is the best place to find me, because I usually have that page open when I'm working, and I'm usually messaging back and forth to somebody in the group pretty much most of the day. So you can catch me in the group a lot easier than you can on the phone. And I'm not an early morning person, so I stay up late. For those of you who get my messages late at night, you know I stay up late, so I don't get up real early in the morning. But if you have an emergency, or if you work a weird schedule and it's hard for you to call me, during the other times, just let me know, and we'll schedule a day that you can call me in the morning, and I'll be up with some coffee so my brain can work and possibly help you. So. Yeah, I'm kind of getting used to how these. There you go. So you guys can go to winningcourtnow.com to get started. My website is set up. The lawsuit package are at the top. I have an online course, and the online course information is at the top too, actually above the lawsuit packages to the left. And then I have some videos on there. If you scroll down further, you'll see the disclaimer, and then a little further, and you'll see the questions and answers section. I like people to go to the questions and answers section before you call me. It would be great if you reviewed everything, you looked at the lawsuit package that you need, click on it, and a drop-down window opens up with the information about the package and some things that you need to know. And then you can do all of that. When you call me, ideally, in an ideal situation would be when you call me, you have your packet already, and you have reviewed it with questions. Now, I know sometimes you're going to have questions of which package or whatever, and that's fine. But in my perfect world, when you call me, you've already made your investment, you got your stuff, and now we can get started with your game plan. Bam, going forward, as opposed to answering the questions that I already have the answers to on the website. So as this business grows, I'm trying to be efficient, so that when people call or when I'm doing things, we're doing things in the most efficient manner, because in the end, it's going to make a huge difference, because, we're going to be helping a lot of people, and we want to make sure that we're in a position to get things done that we need for the people that we're helping. So. Now, I've got a couple of new documents on the website too. I have a marriage dissolution document that you can use if you're facing that situation, but you don't have the money that they try to charge you for getting a divorce. It's funny how it goes. When you get married, they take this marriage license that they sell you that you don't need, and they post it. They put it in the public record to make it legal. And when you get ready to get divorced, they want you to hire an attorney and do all of this rigmarole to pay all this money to the court and go through all of these hoops. And then they're going to take it and put it on the public record to make it not legal. So you can do that yourself. You don't have to go through all of that rigmarole. So I put together a marriage dissolution document, and it's been used a couple of times. I just found it last week or a couple of weeks ago. I'm looking for some other stuff. And actually, I've sold a couple of them. So I'm looking forward to seeing the reviews come in on the new marriage dissolution document. So I think I have it set up so people can ask me questions. I'm still figuring out how to use StreamYard, so I don't see anybody here in the chat window. But if you have any questions about what we're talking about tonight, just leave them in the feed underneath the video, and then I'll answer them for you. Oh, there you go. Is that cool or what? On sale this weekend for only $300. What a deal. You know, I marked them down when the coronavirus started. I marked them down from $850. Well, they were at $1,700. Then they went to $850 because no one could afford $1,700. And then $850 was doing great. When coronavirus started, people started struggling. So we marked them down even further. So this weekend, thanks to HamiltonRadio.net, we are reducing the price of both the lawsuit packages for this weekend. They're only $300. Now, I'm going to show you what you get for your $300. So now I get my screen share set up here. Bam, there we go. So this is the non-judicial lawsuit zip file. And you can see, I think there were 16 documents before I added this. Now, this is the new magistrate judge reconsideration package. If they dismiss your lawsuit without just cause, this is what you need. And I'm going to see if I can click on it to open that up. There we go. So whenever you get a lawsuit package, it's going to come in a zip file. You won't be able to open it up on your phone. So don't even try. And don't call me asking me to send them to you in a PDF because I can't. All of these documents are specific for this, and these same documents are in my files that are specific for other stuff. So it would take me a long time to go through and figure out these documents and make sure that they match the ones in this file. That's why I have them in a zip file. So when you get your zip file, you're going to need to figure out how to open it up and use it. Now, this zip file was added to both the non-judicial and the judicial packages, so you can have what you need to control the judge. Now, this is the magistrate judge consent form. Let's see, I need to click on the other thing here. Objection and notice of claim. Okay. Now, you're John Doe or Jane Doe. Your name goes in place of that. All of the red fonts you would replace with your information about your case, and turn all the red font to black when you're done. I would probably leave it red until you're all done with the whole thing, and just to make sure that you got it. It depends on how you do it. You want to make sure that you delete all of the instructions. And this is what you're going after the judge for. This is pretty serious. And when you file this, you're going to get their attention. And you're also claiming the obstruction of the administration of justice. Most people say it's a due process violation, but my friend that put me on this path has taught me that it's not due process violation, it's obstruction of administration of justice when they're screwing you over in civil court. Violation of constitutional rights under color of law for making a determination without jurisdiction. We're going to keep it simple, because when you keep it simple, it alleviates the arguing. because once the arguing starts, then the judge gets to help them. And that's how they roll. Their whole program is structured that way. So you can see that's the first page of that. Now, let's take a look at another document in. Let me close this up because it's in the way. Okay. So this is the inventory notice of recusal. And people need to read this and pay close attention to it. When you recuse a judge, you don't have to prove. All you have to do is show the appearance of impartiality. And if the judge is ruling without the facts of findings and conclusions of law, then the judge is ruling without jurisdiction. And he's making an administrative ruling instead of a judicial ruling. And that's very, very important to remember, because an administrative ruling is totally screwing you over. And that's what so that's the notice of recusal. And then the notice of appeal template is pretty simple. And this is notes on consent to the magistrate judge. A lot of people have the magistrate judge interfere in their case and dismiss it based off of a report. The magistrate judge makes a report and sends to the district judge, and the district judge dismisses the case based off of the report instead of the findings of facts and conclusions of law. And in most cases, the district judge never even looks at your document to see if it has merit or not. So that's pretty much it on that. The judicial package has less documents, and they're almost similar. But the thing we did with judicial package, we also added this into the judicial package too. So, and anybody that invested in the package that needs this new magistrate judge motion for reconsideration, send me an email to my email address, and I will post that here on the screen in a second, and let me know what month it was that you bought your package roughly, and then I will put this update file in the email to you. It's a lot easier for me to do it that way, because then when you send it to me, I can just click it and send it right over, and I don't have to pull out all my paperwork and try to figure out what your email address is and stuff. And so that's how we're going to do that. So that's all I want to talk about today. If you guys have questions or there's things that you'd like to have me cover pertaining to our program or strategy, make sure that you let me know, and send me an email or a private chat message or something. And I'm going to stop the screen share now, maybe, if I can figure out how to do that. Okay, now we're back. And we're back really big. There we go. Now I can see the banners over here. So I'm going to leave my email address here. Let's see now. when in courts 1 at Gmail. At gmail.com. There we go. Okay, there's the email address. When in courts 1 at gmail.com. So if you guys have invested in the program in a lawsuit package and you need the magistrate judge reconsideration package, just let me know and send me an email and I'll send it over to you. So that's all I got tonight. We're going to try and stream live on YouTube on Friday nights or whenever someone has a bunch of questions or whatever, or when we have an update on something like we're doing on this. And you guys need to make sure that if you use the jurisdictional challenge with an affidavit, that you keep track of the number, you research the number of days that they have to respond, and you keep track of that and be ready. So when that day comes that are out of time, you can pounce on their face and get your stuff filed in court. So that's all I got for this time. I'll see you guys on the next broadcast. Later.